If you don't follow this rule before buying land in Nigeria, you may lose that land. Buying land in Nigeria is a serious business. One mistake can cost you everything. So you have to watch this video and share this video to those persons you are praying to God to buy land, or those persons you know that are into the business of buying land. So the principle, the first one I will share to you is nemo dat quod non habet. It's a Latin maxim. It simply means that you cannot give what you do not have. If you buy land from someone who is not the true owner, the law says you bought nothing. For instance, you are buying a land from someone who has sold it to another person before. So he is the owner, he is the original owner, but he has sold it. You are the second buyer. Since he has sold it, he is no longer the owner. So buying it from him again means that you bought nothing. You did not buy any land. That's what it means. So the second principle is the issue of family land. Family land and communal land. Where land belongs to a family or a community, the consent of both the head and the principal members must be obtained. So consent of only the family head or only one or two members is not enough. So if you are buying from the community, it must be the head of the community, that the paramount ruler of the community, and other principal members like the CDC chairman and the rest must consent before that sale is legal. Sale without the full consent of the head of the family and other principal members is legally defective and can be set aside years later. Even if you have gotten this thing years later, the courts can set it aside if the dissenting member applies to the court to set the sale aside. The third issue is government acquisition and planning issues. If the land is under government reservation, acquisition, or within the government reserve area, any private sale is void. So if this place is marked as reserved for government, you cannot. So that is why we always say, do a survey, conduct search in the Surveyor General's office before you buy any land. Let me tell you another thing now. If a land bought for residential use is zoned by government for commercial or public purposes, you may lose the land or its value. So you are buying a land, then that place has been planned by the authorities to be a commercial purpose, and you are buying it for residential purpose, then you may lose the value. In fact, you may be denied approval to build when you try to obtain building approval or building permits and the rest. They may deny you access. If it is a residential building you want to make, in that place they planned for a different purpose. So you have to be careful. While all these things can be shown in a survey research. The fourth one is the doctrine of lease pendis. This means pending litigation. Once a land is in court, no valid sale can take place. So if a land is in court, you cannot buy that land. So if you buy a land that is already a subject of dispute in court, that sale is void. Even if you bought the land honestly without knowing about the case, the law will not protect that purchase. It is invalid. The land remains under the control of the court until judgment. So please take note of these principles. If you know any other one, you can put it in the comment section, but don't forget to share my video and engage my content. It is very helpful.